Over 60 years ago, William Prosser, a torts expert and law school dean, suggested that states should divide privacy law into 4 categories: intrusion, false light, appropriation, and private facts. Most courts and state legislatures have adopted and continue to use Prosser's categories. Today, we will focus on only one privacy tort law: appropriation. Appropriation is generally using a person's name, picture, or voice without permission for commercial purposes, and is an area of privacy tort law. Appropriation is actually broken down into 2 different torts: commercialization and the right of publicity. Although both prevent the use of someone's name, picture, likeness, voice, or identity for advertising or other commercial purposes without permission, they differ in some important ways. First, let's look at commercialization. The appropriation tort that protects people who want privacy is called commercialization or misappropriation. Commercialization prohibits using another person's name or likeness for commercial purposes without permission. No state has refused to allow appropriation suits, although all courts have not yet ruled on the issue. Commercialization protects an individual's dignity connected with personal privacy, and the courts generally consider commercialization a personal right, but one that does not survive a person's death. Next, we look at right of publicity. The right of publicity protects the monetary value of using a well-known individual's name, likeness, and picture. This is for those people who want publicity but want to control when and how their names and pictures are used, and they want to be paid for the use of their identity. So, the right of publicity protects famous people against unapproved uses of their names and likenesses to advertise or promote services or goods. The right of publicity could be considered a property right, and in many states, the right of publicity extends beyond a person's death. These post-mortem rights of publicity can survive from 10 to 100 years, depending on the state. How do you make a case as a plaintiff? To win a commercialization or right of publicity case, plaintiffs must prove their name, image, likeness, voice, or identity were used for advertising or commercial purposes without permission. Plaintiffs must also show that commercial uses were of and concerning them and widely distributed. A name, image, or likeness must be used without consent and undoubtedly be a representation of that person. Merely sharing a name in an advertisement typically does not qualify. Individuals' voices also cannot be used commercially without consent. Advertisers must obtain permission or provide a disclaimer when using voices that resemble another person. When consent is given, permission is usually for specific commercial uses for a specific entity to use. This does not equate to providing permission to use the image for any and all uses. However, actors impersonating celebrities in non-commercial contexts like satire or parody do not violate their likeness or voice rights, as this expression is protected by the First Amendment. How do you make a case as a defendant? Even if plaintiffs can prove that their names or likenesses were used for commercial purposes, several defenses can still be made. Here are 5 of the best defenses. 1. The best appropriation defense is consent. You will often see releases obtained by professional photographers and event industries, requiring signatures from all parties involved. Oral consent can be a defense, but written consent is more defensible. Consent most often is explicit, but may also be implied. Remember, the law does not allow certain people to give consent, such as minors and those who are not mentally or emotionally capable of agreeing to legal terms. 2. Incidental use typically arises in appropriation claims and not right of publicity claims, meaning a person's name or likeness was used so briefly that the purpose was not significant enough to make a profit or gain commercial benefit. The person could be lost or buried in the overall content. 3. Newsworthiness is a common defense. Media may publish newsworthy material despite having a commercial purpose. Courts define the word newsworthy broadly in relation to matters of public interest. 4. Media advertising is another First Amendment-based appropriation defense that holds mass media may run advertisements for themselves without consent when using the names and likenesses of public figures if those figures were part of their original content. For example, Booth v. Curtis Publishing Company, 1962. The state's highest court concluded that, to stay in business, the magazine had to attract subscribers and advertisers, And in illustrating the magazine's content and quality, with Booth already on a prior cover, the magazine did not violate Booth's rights. And 5. First Amendment defenses in right of publicity cases are common today, particularly in the context of news or artistic works, such as movies and video games. State courts take a range of approaches to resolve appropriation cases, often based on whether the alleged appropriation arises in a commercial context or a First Amendment context. The courts usually apply strict scrutiny when reviewing cases involving the media. However, many courts apply a balancing approach to resolve some right of publicity claims. So far, the Supreme Court has decided only one appropriation case, Zacchini v. Scripps-Howard Broadcasting Company in 1977. In this case, Zacchini performed a 15-second cannonball act, which was videotaped and reported as news. In a 5-4 decision, in favor of Zacchini, the court noted his interest was similar to a patent or copyright, in which he was seeking to obtain the benefit of his work, and the broadcast of an entire act was categorically different from reporting on an event insofar as it posed a substantial threat to the economic value of the performance. Therefore, the First and 14th Amendments do not immunize the news media when they broadcast a performer's entire act without consent. To help identify the issues, most courts apply the transformative use test, which determines whether the First Amendment protects a work that uses a person's name, picture, likeness, voice, or identity for artistic purposes against a right of publicity suit. This has been used to distinguish protected artistic expression about celebrities from expression that encroaches on the right of publicity. This is work that adds enough new elements to the original to transform it and give it new meaning. Examples include satires, fictional works, social criticism, and video games. Another way to balance the First Amendment and the right of publicity is the predominant use test. This test is applied to determine whether uses of a name or picture was more for commercial purposes or more for protected expression. And not used as often is the artistic relevance test, described in Chapter 11 of our textbook. Here, courts assume that using someone else's trademark in an artistic work does not constitute infringement, unless the use is completely unrelated to the artistic work or is deliberately misleading about the work's source. See Doe v. TCI Cablevision, 2003. Overall, courts have long held that the First Amendment protects the use of celebrity names in biographies and fiction, including movies and television programs. So, in summary, appropriation occurs when a defendant uses a plaintiff's name, likeness, or image without permission for commercial purposes. It is one of several torts classified as invasion of privacy. However, if a defendant uses a plaintiff's name or likeness for a newsworthy purpose, it does not fall under the tort of appropriation and can serve as a defense for the defendant. I hope you find this video useful. Thank you.